Good afternoon, everybody. My name is Chris Justice. I'm an associate with Samfiru Tumarkin, and I'm here again on this afternoon to answer as many questions as I possibly can. Of course, all things employment law related. So if you're somebody who has a situation, maybe going into a working relationship, maybe something that's happening during the working relationship itself, or maybe you have a question following the exit or from leaving a work relationship or situation, do get your questions in today. And as always, I will try to answer as many as I possibly can. As you may know as well, I typically start off with some trending topics, some things in the news that relate to the employment law realm. So for today's purposes, I wanted to begin by talking about something that I've spoken recently on before in other ways, that being that RBC, Royal Bank of Canada, is now informing its employees that it wants them to return to the office starting with 3 or 4 days a week. And this is set to begin, or at least come into effect on May 1st. And so I thought it would be a good opportunity to talk about employee rights when their employer is requesting that they come back in to the office, especially after 2+ years of potentially working from home since the onset of the pandemic. You know, a lot of people come to me and they say to me that since the onset of the pandemic and since they've been working from home, they've been able to essentially do their job entirely from home, even though before the pandemic, they were never working from home and they were required to come into the office. And so they ask me if it's practically possible for, an employee to do their job from home. Can I, in the face of my employer asking me to come back into the office, can I tell them that I would rather stay at home as I have been for maybe months or years? And the answer to that is that it depends. It ultimately depends on what the terms of your employment relationship are with that employer. Take, for example, the earlier example I gave about an employee who had worked for a company before the pandemic, never from home, but after the pandemic began working from home. Now, in a lot of these situations, there isn't something in writing from the employer that specifically says you have the ability to work from home for as long as you want. And usually, in a lot of cases, there's a contract that may exist that was actually signed before the pandemic, which speaks to the employee going into the office, let's say Monday to Friday. So even though it may, from a practical standpoint, be that you're able to do your job from home, and that this has been proven over the last months or several years, if there is a contractual right for your employer to have you work in the office, then you as an employee may not have the ability to simply tell the employer that you refuse to go into the office anymore, and that, therefore they should allow you to work from home if that's what you want. Even if you may have moved far away from the office in the last couple of years, even if it may be potentially a big burden or inconvenience for you to have to travel in, that isn't necessarily a basis for refusing to come in. So I think it's going to depend on what contract there is, if it exists. It's going to depend on whether or not your employer ever advised to you that you could work from home indefinitely, or if there was any discussions about a return to work. And it's going to depend as well on a number of other factors. So it's not as easy to say that there's one solution to all this. I think that if you are somebody, an employee who's been working from home for the past however long, and you have now been told you need to come into the office, like as in the case of RBC, you should be getting legal advice. You want to definitely make sure that your communications with the employer are on point, that you're not saying anything that could potentially hurt you later on down the road. And you also just want to make sure that you have a full understanding and awareness of what your options are in terms of the legal aspect of things. And so that's, again, why it's always beneficial to contact a law firm, contact a lawyer, an employment lawyer, to get some advice before you get into the nitty-gritty with your employer when it comes to whether you're going to work from home or not, or maybe if there's a compromise or some sort of negotiation can take place. But The point at the end of the day is that in a lot of cases, your employer can actually force a return to the office. And if you choose not to go back, you may be risked having be seen as abandoning or quitting your job, which, for a long-term service employee who could potentially have very significant severance rights, that would be obviously a disaster. So that's just another reason why you want to make sure that you speak to a lawyer first. But that was the first topic I wanted to address today. Now, there is another topic that involves Shaw. There's a large takeover. In fact, as I understand, the largest takeover in Canadian telecom history has sort of passed its final regulatory hurdle and is about to take place, the acquisition. And I thought that, whether you're an employee of Shaw and you're working for an employer who's going through a big acquisition, or you're an employee anywhere else and your business is, being sold possibly to another corporation or another entity, you need to know what your rights are as an employee when there is a purchase and sale. Because a lot of times somebody who is working, let's say, for one company and then gets told that that company's being sold to another, that employee that's going through all of that, they may be given a contract from the buyer of the business, because the buyer, the company that's taking over, acquiring the business, is oftentimes going to want to have a number of employees stay on board with that transition. So a lot of times the buyer of the business is going to present the current employees of the business that's being sold a contract, some maybe revised contract, a different type of an employment agreement that might be, might have significant differences than what the first contract was with the seller. And a lot of employees, when a purchase and sale happens, because they want to keep working and make sure that there's no break in their employment, they're going to sign a contract that's been given by the buyer, the purchaser of the business, without really thinking too much of it. And actually, unbeknownst to them, could very well be giving away a lot of rights that they had with the seller that now they no longer have with the buyer, because the buyer's contract, as I said before, is potentially being worded in a very different way and probably likely to the benefit of the buyer. So this is another scenario where you, as an employee who's sort of going through a purchase and sale, you're going to want to have to talk. You're going to want to speak to a lawyer. You're going to want to get legal advice to make sure that, first of all, before you sign anything, you exactly know what this contract is saying. But secondly, if the contract you're being told to sign is very different, or the terms of that agreement with the buyer are very different than with the seller, you as an employee may very well have an option to say no to the buyer's contract and get paid your full severance rights from the seller. So there's a number of different options or possibilities when it comes to trying to deal with a purchase and sale, whether it's getting your full severance from the seller, whether it's, trying to figure out whether or not you are required or in some way there's pressure on you to join the new company, or whether you're within your rights to refuse any new contract that's being given to you because of there being a huge difference. So as I say, it's another situation where you want to talk to a lawyer, you want to get legal advice when you're in the midst of a sale of business happening, because these contracts can really, do you a lot of damage or a lot of harm in the future. And they may not necessarily appear to do that when you first sign it or when you first look at it. But with that said, I'll get into some questions from you guys. So just bear with me here. I've got a question on from YouTube from Renee, who's asking or is wanting to know if they are entitled to a severance package after working at their job for 30 years because they were fired on the basis of refusing to take the jab. So the jab, meaning the COVID-19 vaccine. It's a very common situation, especially nowadays. People are essentially being terminated for refusing to get vaccinated, for refusing to comply with their employer's vaccination policy. Or maybe if they're not being fired, like in the case of Renee, they're being placed on a leave of absence that's unpaid and for which there's no end date. And people need to know that they have options in these scenarios. that there is, in fact, a good chance that if you are somebody, in fact, maybe a very good chance that if you're somebody who's lost their job as a result of non-compliance with a vaccine policy, that you have severance rights, that you have the ability to get severance rather than getting nothing or being placed on an unpaid leave of absence for an indefinite period of time. Much like I was mentioning earlier, it may come down to whether or not you've signed a contract, what that contract says, the industry that you work in, and whether or not there's ever been any kind of regulation or mandate in place regarding vaccinations may be a factor. But in general, if you're an employee, especially like Renee with 30 years of service, and you've been let go and possibly given zero severance because you haven't complied with their vaccination policy, you need to give us a call right away, because you probably don't think this, but you actually do have a lot more options than you may think. And one of those options could be pursuing your full severance, which after 30 years of employment could potentially be a very, very significant amount of money. So if you're somebody like Renee or Renee herself, you want to give us a call when you're in these situations about non-compliance and vaccine policies, because it can be a bit tricky, but there are options available to you. And so, yes, thank you for that question. It's definitely one that's been something more and more common ever since employers have started implementing their vaccine policies, which in my experience is dated all the way back to late 2021 or even a bit before that. Moving on, I've got a question from Sunny on YouTube. Sunny's saying that for the past 10 years, as part of the employment package, he's been given a company car for business use. And so that's covered expenses like gas as well as personal use. But there have been new owners with the business. So going back to purchasing and the selling of businesses, these new owners of the business now want to change Sunny's employment terms regarding the company car and the expenses being covered to only being business use, not personal use, and potentially limiting the car package or the car allowance in some other way. And Sunny's asking what the options are, what rights Sunny has when it comes to these scenarios. So this is another good question, again, involving purchasing and buying of a business. But in general, whether it's involving the sale of a business or not, if you have your employer and you've got a set term with him or with the employer regarding a company car, especially if it's got a lot of value to it, and your employer makes changes to the terms of your employment, whether it's taking away a company car, limiting its use to only business use, if that ends up or is seen as a big change, a significant change to the terms of your employment, even if the change itself is not motivated in bad faith or malice, you as an employee typically have the option to agree to the change. You can say yes to it. You can possibly try to negotiate the change and maybe come to some sort of a middle ground, or you can take a stand and stand firm and say that you're not agreeable to the change to your employment because it is such a significant part of the overall compensation package. So that's why I say it goes back to how significant of a change is it? And if it is, those are generally the options you as an employee have. So don't think that you have to accept any changes, because once you do, it's going to be next to impossible to go back and try and reverse that. So again, you want to talk to a lawyer before speaking with your company on this, before you might say something that could cause more harm or more damage. But any time where an employer makes a significant change to your employment without your consent, that's what's known as a constructive dismissal. And a constructive dismissal in the eyes of the law is treated very much in the same way as a termination without cause, which could then result in you getting your full severance entitlements, even though there hasn't been a technical termination, and just on account of the big change to your employment itself. So as I say, whether it's in Sunny's case with respect to car allowance or the provision of a car or the benefits that flow from that, it could also involve a company changing your pay or removing some other benefit that you might have. It could result in a company, changing the location in which you work potentially. So there are a number of different changes that can happen to someone's employment that, again, if significant, would result in a constructive dismissal and would give that employee the ability to seek full severance against the employer. But as I say, before you get into all those discussions with the employer, you're going to want to have a discussion with a lawyer first so that you're saying the right things that need to be said and so that you're protecting yourself later on should there be an issue. And I will just make one other point regarding Sunny's question and also regarding some of the other stuff I've said when it comes to getting advice from a legal perspective. You're going to want to record your communications ultimately, whether it has to do with a change in the terms of your employment or whether it has to do with maybe a new contract that's being given to you or just your employer communicating to you that they want you back in the physical office. Once you have received the appropriate legal advice, part of that advice will involve making sure you document and record these communications with your employer so that later on, it's not going to be a question of he said, she said. And if there is a dispute and a breach from your employer's perspective, you're going to have the documentation and the records to back it up later on, which is going to help any kind of a legal case that you have in the future. So that's very important. But thanks, Sunny, for the question. I've got another question in from Maria on YouTube. And Maria's asking or saying that her past employer never provided a pay stub for the full year that she worked, and she cannot confirm, therefore, her income and is asking what can be done. So it's a good question, Maria. I take it you've asked for the pay stub, but if not, I'll always say write to your lawyer again, going back to keeping things in writing, making a record of it. Send an email to your lawyer asking for that pay stub, that you haven't been provided with that pay stub that shows the year-to-date earnings, that you in fact worked that full year and that you're asking for it. And as I say, put that in writing so that there's a paper trail. If your employer then refuses to provide you with the pay stub or has some kind of response in writing, then that's going to help with all that record keeping. But that's the first thing I would say. Maria, you should also, apart from any pay stub for that final year, you should also be likely provided with a T4. And that would be another request. In addition to any pay stubs that you may want, your employer should be issuing and providing you with a T4 if you have earned income with them. This is a requirement by law. So if they don't provide a T4, then they could themselves get into an issue with respect to either the CRA, possibly just Service Canada, those that work in the EI department. But there may be some options for you to contact a government agency to get them to follow up in having this employer comply with its requirements. And the T4, like the final pay stub, is also going to show how much income you've earned. The other thing I might suggest, Maria, would be to see what documents you have. If you've been receiving pay stubs throughout that year, obviously you can check there. If you've got bank deposits or bank slips, although that would generally reflect the net income, that could be another possibility. But in general, there shouldn't really be a huge issue with the employer providing a pay stub. So if after asking at least once or twice to the employer in writing for the pay stub or the T4 that they still don't respond to you, I'd say give us a call and we can definitely take it from there and let you know what your options are, in addition to anything I've said already. But thanks, Maria, for the question. Actually, I've got another question from Maria who is stating that her previous employer is suing her because she left the company and they say they lost revenue due to her leaving. And Maria's asking what she can do. So generally speaking, if you are an employee and during the course of your employment, your employer loses revenue, that is not going to be enough to ground any kind of a lawsuit or claim against you. First of all, the employer would have to prove that the revenue was lost specifically due to you leaving, because revenue, frankly, can be lost in a number of ways. So there may not even be any connection or real connection to you and the lost revenue, but they're going to have to prove that they both lost it and that it was due to you, which can be extremely difficult. But not only that, they would have to prove that they lost revenue specifically on account of you for something that you did that was very egregious. Like, for example, if you or an employee for that matter stole from a company and that led to a loss in revenue, that's a lot different than an employee who maybe doesn't perform the best and the company makes losses. Those are two entirely different situations. And still, in general, I think it's going to be very difficult for your employer to successfully sue you just because they lost revenue. So I would say, Maria, it very well will come down to the specifics of your case. And this may be something that you want to give us a call about. If the employer is suing you and they've actually served you with formal papers, then I would imagine the details of the allegations against you would be in those papers. So it's not to say it's not possible for an employer to sue a former employee, but in a lot of circumstances, while they may think they can do it, they just can't. And it may, in fact, be an intimidation tactic, or they could just expose themselves to being seen as doing that in bad faith, which could kind of open up on a whole nother can of worms. But again, Maria, I would say you definitely want to get in touch with us, because if there's an actual lawsuit that's on the way, that can still be a very serious thing, and you want to make sure that you address it appropriately. But like I say, there's got to be a lot of hurdles that the employer is going to have to go through or get past before I think it stands any chance of doing that, normally speaking or generally speaking. I've got another question in from Kelly on YouTube, who's asking whether or not there's a difference between severance pay and termination pay. And these phrases, actually, severance pay and termination pay, are used pretty interchangeably and oftentimes will mean the same thing. So I guess it depends on who you ask. There are concepts in law. One's called notice pay or termination pay, and the other's called severance pay. And they do technically refer, or can at least technically refer, to different portions of pay that you're owed. But it's all under the same sort of umbrella in terms of your termination rights, your rights upon termination. So when I've used severance pay, for example, full severance pay, that phrase during today's Q&A, I'm referring to termination pay as well. I'm referring to all of somebody's entitlements when it comes to, or at least their potential entitlements when it comes to severance that they're owed. So if you see someone say severance pay or termination pay, it could be that they're only referring to a portion of what somebody might be owed, but it could also be that they're referring to the whole lot. So in general, Kelly, I would say that would apply just in terms of the total severance that you're owed, if you ever hear those terms. But if your employer, for example, is mentioning these phrases, severance pay and termination pay, and you're not sure as to exactly how much they're referring to, again, definitely give us a call, because this is something that we look at on a daily basis, and we'll be able to advise you. I've got another question in from Aaron on Facebook. Aaron saying that they worked for a company as a sales rep for 18 years, but they were classified as a contractor. They were terminated in January of this year when they changed their wholesale structure. And the company said that they followed the law for terminations. And since Aaron was not an employee, because again, they called or classified Aaron as a contractor, that the employer does not believe they owe Aaron any real severance. So Aaron's asking if this is accurate. And it's another good question, because a lot of people will come to me and tell me that they believe themselves to be contractors and actually convince themselves that for that reason they're not owed money. Maybe because their employer has said something, maybe because they looked up something online. But people, when it comes to this issue, need to be aware that the label does not matter. Your employer and even yourself cannot determine if you are a contractor or an employee just because there's a piece of paper or a contract that says so. Ultimately, the law is going to be what determines whether someone's classified as a contractor or an employee. There are situations where independent contractors are not entitled to severance. But then there is a lot more situations where somebody gets called a contractor, but they're actually an employee. Or if not, they're a dependent contractor, not independent, but dependent. In these situations, you are entitled to severance. So a lot of people, like I say, get fixated on the label or the title, but they don't actually look at the relationship they have with the company itself. And that's mainly what's important, is not so much what somebody calls you or what a contract refers to you as, but what is the relationship? How much control does the employer have over you? The more control, more likely you're going to be owed severance. How much do you depend on this employer? Do they make up 100% of your income? Do they make up the vast majority of your income? Even if you're a quote unquote contractor, maybe you send them invoices, maybe you take care of your own HST. That still does not mean that you are necessarily disentitled from any severance. So there can actually be examples of a more contractor-like existence or relationship, but still be considered an employee. And that's another thing I think people need to be aware of, because they think that because they take care of the taxes themselves, or they've got a professional corporation that they send invoices through, that automatically means they're not an employee. And maybe because they've got a contract that says they're a contractor. Again, one or two or three factors alone are not going to be what determines the relationship. You've got to look at much more than that. And that's why in these cases, you definitely want to get some legal advice, because if you're an 18-year employee and you're being told that they're not owing you, or they don't owe you any severance, when you could get upwards of 2 years of full severance, that's a huge amount. Even if it's just potential, there's a huge difference there. And again, all the more reason why legal advice should be sought, and a decision should be made after that. But Aaron, there's, in my experience, a very good chance that you are entitled to severance. There's a chance that, as I say, you can get upwards of 2 years of severance, given all the years of service you've put in. So you definitely want to give us a call. Or if anyone like Aaron is in that situation where they're being told they're a contractor and they're not owed any severance, especially if they've been there for a long time, you're going to want to give us a call as well. I've got another email in from Sunny, and this is actually, I think, just a follow-up from Sunny's earlier question that had to do with his company making changes to the company car plan. Sunny is saying that the contract he has doesn't mention anything about car compensation, but that his previous employer had nonetheless been providing full coverage over the last 15 years. And that's important, Sunny, because not everything needs to be in a written contract for it to be a term of your employment. As you say, if you have over the last 15 years simply been receiving this coverage, or if an employee over the last 15 years has been receiving a bonus of $5,000, again, it doesn't really matter, it could be anything, then it's reasonable for that person to expect that to continue. And expectations based on either a written contract or just day-to-day how things have been operating, especially over 15 years, can actually create a term of your employment that's implied. It may not be expressly written down, but it can certainly be implied. So Sunny, if you've been being given coverage for 15 years and in year 16 that changes without your consent, then I think it's entirely reasonable for you to say that that was a term of your employment, even if it wasn't written down, and that you had a full expectation that that would continue. And regardless of whether or not the new company coming in feels it's in their better interest business-wise to remove it, that doesn't necessarily allow them to get away with making the change itself on you. Again, especially provided it's a significant one. But it's a good follow-up, Sunny, because people can have terms of their employment created just by virtue of what's actually gone on over the many years, and it doesn't have to necessarily be in writing. So that's another good point. Maria is following up as well on some of her questions. Maria was earlier talking about her employer not being given a pay stub. She's trying to confirm income, as well as her previous employer potentially suing her. Maria, you're asking or saying that you need to contact our firm because you've been actually served with the court papers. So absolutely, it's not to say that these things shouldn't be taken seriously. They absolutely should, even if there may be no merit to the employer's case against you. There are certain timelines as well that you're going to have to follow once you've been served with papers. So that's another reason why you want to get in touch with us sooner rather than later, so that things are done in accordance with the rules and that there's no issues there. But yeah, definitely give us a shout, Maria, and thanks again for following up. That pretty much does it for my time today, everyone. I do thank you for all your questions. I will be back As I say, just get your questions in whenever we do these things. And in fact, our next live stream session is going to be April 4th, which is Tuesday, 3 p.m. Eastern with Madalena. So do get your questions in when she gets on. Again, anything all employment law related, and I'm sure I'll see all of you in the near future. But until then, do take care and have a great rest of your day. Thanks very, very much. Bye for now.